Hello and welcome back to the Natural Law Moment. I'm Garrett Snedeker, and as always, I'm here with the James Wilson Institute's two co-directors, Professors Hadley Arkes and Gerry Bradley. Hadley?
Yes, we wanted to get into this Grametti case from Tennessee dealing with transgenderism, with the legislature barring parents from ordering up these surgeries that have a disfiguring effect on children. I used to take my own summoning line these days, and I never thought I'd live in a country, live in a regime, in a government, in which a legislature could threaten to punish parents or remove custody of children from parents if they sought counsel for a child who's undergoing uh, confusion about his sexual orientation or his gender. We have that now, but now with Tennessee, we have the adverse side of it. We have parents who are earnestly willing to order up what they consider gender-affirming care. And it falls to our friend Jeff Sutton in the Sixth Circuit to have to explain why the law would be justified in overriding those parental rights. And one of the difficulties we get here, as Gerry and I can consider, is that Sutton is really not sure there are such things as parental rights. He takes the side of our late friend Nino Scalia that thinks they may be a product of substantive due process, that the court backed into this back in the 1920s with the old Meyer versus Nebraska and Pierce versus Society of Sisters, on the right of parents to order the education and of their own children, whether their children are being taught in German or whether they're going to be in private schools. And some of our friends consider that rather suspect because those parental rights are never placed in the Constitution. They're just brought through the due process clause. And so there's a certain kind of uncertainty here about in Jeff Sutton. But let me just recall where the statute goes and give it over to Gerry with our common problem here. The healthcare provider may not administer or administer a medical procedure to a minor for the purpose of either enabling a minor to identify with, live as a purported identity consistent with the minor's sex, or treating purported discomfort or distress from a discordance between the minor's sex or asserted identity. But you and I think there's a deeper argument that could be made for that statute. No, I think you've made the case for it.
Well, I do. And the statute, of course, affects and pertains to what the statute and statutes like it typically call chemical and surgical mutilation, which is to be distinguished, I think, in this context from what's usually called social transition. So again, we're speaking for the moment of minors, and social transition occurs perhaps most often in a school environment and has to do with pronouns and first names and access to bathrooms and protocols about how other children should treat a transitioning little boy or little girl. But on the matter of this statute about chemical and surgical mutilation, I think one solid moral and legal ground upon which the case could turn, and I frankly think should turn, is in the nature of these procedures as being, that is literally what they're called, which are mutilations. Now, I think mutilation is always wrong, and certainly it's always been condemned by any kind of respectable medical professional, and it's been condemned by the common morality from time out of mind. And I think it is an adequate basis for upholding this statute. Of course, to uphold it on that basis, again, which is not an extravagant move because it is what the statute calls these procedures, you'd have to have a sound and even supple grasp upon what exactly is mutilation, how it's not medical practice, and what's wrong with it. But that would be an exploration of, for the most part, moral philosophical reasoning. And that is, in some respects, or up to a certain point, anathema to many judges today. But a second way in which the statute, I think, should be and could be sustained would be not to treat it just as the way, and not so much that Judge Sutton treated it this way. I mean, I think Judge Sutton treated the statute exactly the way it was written. which is to say the statute is written really, and the legislative findings accompanying it are really make the statute an informed consent statute. Now, the Tennessee legislature, as well as their lawyer in the Supreme Court, declined to take the strong stand about mutilation, and further declined to take the strong stand that they could have about the overall effects of these interventions on minor children, which is to say, the other solid moral ground would be that these are procedures which are simply harmful. And not only, as the statute says, should no one choose them or try to choose them before they're 18, they shouldn't be chosen at all by anyone. But that would require, by the legislature, on the part of the legislature, a frank appraisal of the true nature and scope of these procedures. Now, the legislature didn't do that, so they handed off, you might say, figuratively, to Judge Sutton what we have on hand, which is an informed consent statute. And there's certainly no fault on Judge Sutton's part to take the statute as it is given to him and then proceed to evaluate it as best he can according to constitutional metrics. But as I say, these two strongest grounds for sustaining the statute were not pressed upon the Sixth Circuit, namely mutilation and the fact that these procedures are, in every case, harmful and not to be done. So the case comes to the Sixth Circuit with an issue raised about the scope of parental rights. But of course, that would be a non-starter if either of these two grounds were the grounds at hand. That is to say, it's easy to see parents don't have a right to authorize mutilation, and parents don't have the right to authorize harmful medical procedures for their children. So the case becomes a somewhat unusual, and I think sort of distorted parents' rights case, precisely by abandoning or not pursuing the most solid moral grounds for sustaining the law.
Well, look, as you said, you've made the point that sex, the differences in sex permeate the cells, that sex is an immutable condition. So that the hard truth of the matter is that these procedures are predicated on a falsehood. Isn't that the case?
Correctly, absolutely.
And
there's no doubt one cannot change one's sex, and one can only pathetically and dangerously try to simulate some of the appearance of a member of the opposite sex. So what you really have, I mean, and that truth, I don't think is a matter of philosophical speculation. That is to say, you can't change your sex. Any biology textbook, anybody who knows anything about the human anatomy and the biochemical composition of the human body could tell you that. So that truth is not, let's say, one of adventurous philosophical speculation, and should always be in play in any case in which it's relevant, but in this case with regard to attempted sex change operations. I don't regard even a philosophically diffident judge, I don't think even a philosophically diffident judge should hesitate for a split second to affirm that sex, our nature as male and female, is not only innate, it's also immutable and indelible.
Okay, so the question is, why can't the judges be moved to that level instead of taking what I say is the low door under the wall again to try to just settle this on the ground that the legislature is making a decision? One of our dear friends, an accomplished federal judge, looked at Jeff Sutton's opinion and said that Jeff Sutton was holding to the deep wrongness of these kinds of surgeries. That's not how I read the opinion. What I read Jeff Sutton to be saying was that Jeff Sutton was holding to the authority of the legislature to make a decision on a controversial matter. And as far as I read that decision, it would be perfectly compatible for Sutton to turn around in another case where where the statute is supporting the rights of parents to make these gender affirming decisions for their children. Now let me recall how he cast this matter. He says, the question is whether the people of this country ever agreed to remove debates of this sort about the use of new drug treatments on minors from the conventional place for dealing with new norms, new drugs, new technologies, the democratic process. And when it came to parents, he said the Supreme Court cases recognizing the rights of parents, confined it to narrow fields such as education, visitation rights. No Supreme Court extends it to a general right to receive new medical or experimental drug treatments. You and I talked about this earlier. This all brings back to me the early arguments about the Bill of Rights, where the crusty Theodore Sedgwick was saying, why don't you specify my right to get up in the morning, my right to walk down the street? In other words, he was expressing what we call a classical liberal view. That we begin with a presumption in favor of those rational creatures, moral agents, to make up their own judgments about their own acts and how they're going to make their livings, whether they're going to be braiding hair, shining shoes. And it falls to the government, to the law, to bear the burden of showing why what they're doing may be unjustified and warranted restraint. But the assumption here is that, no, we begin with the authority of the legislature to make decisions. And the legislature then just apportions out to parents or to individuals, you say, the authority to make judgments about their own medical treatment. This seems to reverse things and have things all the way around. And
Right.
what bothers me is about this, it removes the moral richness that must come in play on either side of the case. If we're talking about parental rights, we say, well, parental rights, yes, it's a moral concept. It occurs within a moral framework. But as the framers understood, for every liberty we can mention, there is a correlative form of license. Every liberty we can mention be directed to rightful or wrongful ends. It means we could make a case for why a right should flow to parents to make decisions governing their immature children and in making decisions about their education and their medical treatment. But on the other hand, we understand license. There could be parents who misuse them, parents who will rent out their children or direct their children to wrongful ends. Now, the problem with Sutton's opinion is that first, we don't begin with recognizing that there is a moral ground for rights of parents. On the other hand, there's a moral ground that justifies the intervention of the government. And in this case, it flows to the government to make that case. What we find harmful in these procedures. And the problem, Gerry, that gets to both of us is what is we had friends the other day and judges around the table, and there seemed to be a deep reluctance on their part to have the judges moving to give the strongest argument, the argument that indeed would supply the deepest justification for these laws and territories. What's holding our friends back?
Well, in this case, I don't quite think that the fault, if that's what we should call it, is with Judge Sutton. I think the fault runs back to the Tennessee legislature, which articulated what I regard to be weak grounds, or certainly the weaker of the available grounds for this statute. Right. And I think that is the legislature's diffidence about the real grounds for the law they were passing, I think reflects pretty clearly where the Supreme Court is. And because the Supreme Court is, the lower courts are. So to put that in different language and hopefully more clearly, I think what you're seeing in the statute and the grounds produced therefore, and even the form of the argument taken by Tennessee's lawyer in the Supreme Court, you're seeing reflections of the Supreme Court's demonstrated moral reticence on all sorts of normative matters. So I do think that Judge Sutton certainly shouldn't be faulted for taking up the statute that he is dealt or given, and that the real problem lies in the not equivocal, but in the weak and somewhat confused basis for the law that he was given. So, for example, it's an informed consent law, but it presumes, and I think implicitly holds, that these are procedures that would be morally eligible and, in fact, should be available to functioning adults. Now, I think that is false.
Right.
And similarly, as you say quite rightly, parents' rights enter into the picture at the get-go and are not in some way derivative of government authority and certainly aren't a function of government permissions. So parents have rights that correspond to their parental duties. But in this case, the short answer to the claim of parental rights is that, as you say, parents don't have a right to pimp their children nor to mutilate them, and it's that simple. But to premise the statute on those grounds would require greater moral forthrightness than was produced or at work on the part of the Tennessee legislature. And I say that reflects the advice they're getting from lawyers, their own counsel, to the effect you can't go into our courts these days defending this law on the simple but nonetheless profoundly correct grounds you can't change your sex. Attempts to do so are delusional and harmful, and attempting to do so through chemical and surgical interventions amount to mutilation. Now, that all is true, but it's too frankly and straightforwardly moral for the comfort of even some of our conservative judges. But I trace that fault or flaw first to the State House, and then what Judge Sutton does in the Sixth Circuit is to, I don't know what the best expression is, but he manages to make the best omelet he can with the eggs he's been given.
Okay, but what I'd say, what you've just put forth, Gerry, I take to be the most coherent account one could give of why we're having this statute in the first place. But you're right. The lawyers in their own brief for Tennessee Civic cast it in terms that Jeff Sutton picked up. They'd say there is no deeply rooted tradition of preventing governments from regulating the medical profession and certain treatments. And in the same way, there is no deeply rooted parental right not to accept certain particular medical treatments. It's really narrowing this, which opens it to the challenge I was posing. Yeah, they've done it this way. Jeff Sutton is willing to move within the contours of their argument. The challenge I put forth was this: why would we have to settle for an opinion, as Sutton puts it up, that would be the equivalent of a concurring opinion in Buck versus Bell, the most reviled case in our set, the case from 1927, compulsory sterilizations for Carrie Buck in Virginia, thought to be slow of wit, with Trump that had famous line, 3 generations of imbeciles are enough. So what are we saying? As Trump would say, oh, it's a controversial matter. Well, it's controversial here and only because we've indulged the fantasy that males could be converted into females and females, or there's something subjective about what is really an inescapable truth. It has suddenly become controversial. Some of established people, educated people, favor it. They're willing to vote in favor of it in their medical professions. And we just sustained this. We just sustained this law. Yep. Jeff Sutton has written eloquently about the matter of Buck versus Bell and compulsory sterilization, which sharpens my point. Why would he have to come up with an opinion that would be could serve well as a concurring opinion in Buck versus Bell? So Gerry, putting it back to you, you've just given, I think, is the most coherent account we'd have to give. What is it that would, why would Jeff Sutton be compelled, or any judge, be compelled to work within that flawed scheme that the legislature or their lawyers have come up with here?
Well, one answer would be he's not in an apex court. He's subordinate to or an inferior court to the Supreme Court. Now, I think that the question that you raise is really pointed best towards the Supreme Court, because the Supreme Court now is deciding Scrimeti, has a very able opinion from below to work with, but the Supreme Court not only may rightly, according to judicial canons or the way judges properly reason, but the Supreme Court, when it decides Scrimeti over the next whatever number of weeks, should not only be looking at Scrimeti, it should be imagining itself looking at the case you have in mind. What if a legislature in another state took a contrary view of the medical evidence and scientific evidence and authorized these procedures for minors? And maybe in some states
right,
would criticize and maybe penalize parents who didn't get these procedures for a gender dysphoric child. So the Supreme Court has to ask itself, even if Jeff Sutton, in a certain respect, couldn't, the Supreme Court has to ask itself, well, if affirming Jeff Sutton depends upon a rational basis based upon the scientific evidence to think these might be harmful for children, then a statute in a state where the legislature judged the contrary, that the evidence supports the view that these procedures may be helpful to children, the Supreme Court would be left having to decide whether to write an opinion in Scrimeti that leaves it wide open to having to affirm a contrary statute. And that statute, in essence, is before the court already, because the court has agreed to review the Colorado statute in Childs versus Salazar. Now, that's a case about not surgical interventions, but more about counseling, and you might say social transitioning, widely understood. But the Supreme Court, when it decides Scrimeti, should have in mind Childs versus Salazar, which is the Colorado ban upon what Colorado calls conversion therapy, talk therapy intended to, with the purpose to, as they said, change a child's sexual orientation or gender identity. Now, the 10th Circuit upheld that statute, and the Supreme Court should reverse the 10th Circuit, but it ought to do so. It should start thinking about how to do so already in Scrimeti. So I don't think that the Supreme Court in this context can get by on, let's call them, the morally modest grounds that were sufficient, I think, for Jeff Sutton. The Supreme Court has a much bigger set of questions to resolve, and as an apex court, it's going to have to offer magisterial guidance. And it can't help but see that percolating already up through the pipeline are various challenges to Trump executive orders on transgender matters. And the Trump executive orders, thank God, are completely rooted not in scientific evidence so much, but in the truth of the matter. The Trump executive orders, one after the other, state flatly biological sex is real, gender identity is subjective and delusional and unreal, and that if you decide to repudiate your sex and live according to your imagined subjective gender identity, now the Trump administration may be going too far in some instances and saying, then you are not simply fit. The Trump administration draws conclusions from that reality, the delusion, you might say, of transgenderism.
Exactly.
And says in so many different contexts, you're not suited to be in the military. You're not able to critically evaluate scientific evidence. You don't even care about the truth. But my point is the Trump administration executive orders, whatever else you think of them, whatever anyone thinks of them, surely and squarely present a rationale for the operative parts of those orders that's rooted entirely in the truth of the matter about transgenderism as a delusion, as a kind of narcissistic extravagance, as living in a dream world, you might say. But the court will eventually have to face up to that, and it will not be available to the Supreme Court to say, well, there's a rational basis for thinking this, and maybe there's a rational basis for thinking that. The court is going to have to deal with assertions of truth, both biological and moral, and it's not going to be able to avoid confronting them as putative truths.
Now, I was going to write to our friend Justice Alito with that pitch I was making about why do we have to settle in with a decision that'd be a concurring opinion in Buck versus Bill. But we should get a transcript of what you've just said, because that should be the other part of my letter, which sets up this interesting problem, though, Gerry. On this last weekend, we were talking about this. We were assuming that it was going to be the low door under the wall again, that what the court would do is more likely just to sustain Sutton's limited opinion in Scrimeti. But what you're saying is your judgment is what they really should go the rest of the way to the truth of the matter.
Right.
But
Well, I
isn't
think, I mean,
that,
affirming simply on the basis of what Jeff Sutton wrote, which is ordinarily a prudent path to take, I think will be short-sighted. And the court, I don't think this is something you do on the sly. I'm not suggesting the court would be out of order or out of bounds in any way. I think an apex court should resolve the matter at hand in light of pending matters of a similar nature or matters that are related in some central way, but in some other superficial ways are quite different. I think the court, and it's not a matter of judicial legislation or anything of the sort, the court should wrap its mind entirely around the issue presented in Scarametti and found an opinion, affirming Jeff Sutton for sure, on solid enough ground to put them on solid ground or to retain the high ground, you might say, in Childs versus Salazar and in the cases challenging the Trump executive orders.
that's so we have at least two votes for that, and then that gives us a test of what is going to happen. But look, why is it inadmissible for a judge in an important appellate court to come out with these? I mean, we had Henry Friendly years ago, a great federal judge, who deal with a case on uh, uh, testifying against oneself. And it's like, why? In the appellate court, why would it be illegitimate to ask someone who's been involved in the kidnapping to tell us, given what you know, is the victim still alive? Is he still in this country? Why is it inadmissible to ask? I mean, judges in the lower court were able to raise questions of that kind. So I don't see why it would not have been possible for Jeff Sutton to say, look, we have this, but look, if you're looking for the most coherent account or the truth of the matter, we really have to go to the truth of this case, that this doesn't make much sense until you realize that the whole thing is predicated on a falsehood. And in fact, given time, most people will just talk themselves out of this. So
well, that's for sure. And I don't know why I don't see any mention in the Sixth Circuit opinion or in the oral argument of what I think is, as far as I can tell, unmentioned but critical fact. There is mention, I should say, there is mention in the legislative findings of, and in Jeff Sutton's opinion, of what you're referring to, which is the not so much the rate of detransitioners, which is something that's featured very much in the statutory materials. That is to say, it's an informed consent statute that seems to take the most relevant statistical finding to be what they call a high rate of detransitioning, meaning all too many people who, as children, are subjected to these unfortunate procedures end up as adults regretting it. Now that is a fact, and it's useful to know that fact. But what I'm saying is there are two other facts, one of which you just mentioned, that I don't think played a role in the case, and they should have. And those two facts are that I think everybody recognizes that somewhere north of 85% of minors who report or say that they are in the wrong body naturally desist. That is to say, they outgrow that those feelings of maladjustment. So that is not a detransitioning statistic. That's a natural desistance statistic. And the truth is probably I think it's 90% or higher, but I think everybody agrees it's 85% or more. And the other fact is the following, and again, I don't think it was in the legislative findings and therefore not in the court's opinion. I think the truth is that the endocrine society, the pediatric societies, the professional societies who are behind, who are on the wrong side of this matter, who are behind these procedures, don't even claim to have reliable diagnostic tools to identify those children who will naturally desist from those children who won't. That is to say, they have no way of sorting out that 10 or 15% of children who report being transgender, who would not naturally desist. And the other fact, I guess a third fact, which is not in the materials, is the following: 90-something% of kids who are started on these drug regimens, puberty blockers and cross-sex hormones, end up going all the way through to surgeries. So to put all of these things together, you have a kind of medical scientific house of cards. That is to say, the profession is without diagnostic tools, so that they're blindly filling these kids through full of drugs, knowing that most of them don't need it and will naturally desist, even knowing that some of them eventually will live to regret it and become detransitioners, but also knowing, they should know, that once you start a kid on this pathway, they are going to be locked into it.
Right.
So I think that looking at all of that evidence, which I think is very widely agreed or very widely recognized body of information, that the legislature should have just said, you can't do this. And it's not a matter of waiting until you're old enough to decide to do this. You can't do this because this is harmful. This is mutilation and psychological destruction of what will or is or could be a healthy psychosexually functioning child, adolescent, and teenager. But that would be strong medical grounds, but in support of a solid and unequivocal moral judgment. But there's a reason why that's not the way these cases tend to go. And it's because precisely of a moral reticence cultivated, I'm sorry to say, by too many conservative members of the Supreme Court.
But what you're saying is it reduces simply to this: the so-called malady disease. We don't know, have no standards for judging whether it's an enduring state of affairs,
Correct.
whether it's merely transitory. If somebody
Correct.
has, if you have a diagnosis of cancer, we know what it is, and we know what the prospects are for its longevity, when we might, if it could be brought to an end. Here we don't. Let me take, since we our old project is natural law. Let me circle back at this moment. With this matter of parental rights that comes into play with this kind of thing. And Jeff Sutton seems to absorb the notion of our late friend Scalia, that there's something sort of suspect about parental rights. We don't know what its limits are because it came to us in substantive due process, came to us through the due process clause, those earlier cases of Meyer versus Nebraska and Pierce versus Society of Sisters. And for me, it takes us back to the great Thomas Cooley in his commentaries on the Constitution. Thomas Cooley, who was my friend George Sutherland's professor, and Sutherland had just 1 year of law school with Cooley. And Cooley taught that, well, the due process clause was really the device to which to draw out the implications of natural law that the founders could not possibly have thought they'd have to put, didn't have the imagination to put. Who would have ever thought that one would question the authority of parents to direct the education or the medical, whoever thought of it? Of our dear friend Dick Holmholtz in Chicago would say, what about the notion of a summons in natural law? Anyone who's targeted for prosecution should have a right to know he's being targeted. No, right. So he has time to prepare his defense. If a judge suddenly, as Cardozo would later say, well, if there must be a trial before a verdict, there must be summons. And if a judge came out with that, would he be sort of inventing things, as some of our friends would say? Or as our late friend Bob Bork would say, would he be simply looking inside himself when he came up with something like that? Or would he not, in fact, be seeing the implications that arise from the very logic of a moral judgment and the natural law? And so one of the curious things here is that our friends don't quite seem to credit this notion of parental right. They're not sure what standing to give it, what the moral ground is of it. And we could supply them all. We could explain. We go back with the old line that, my outline of this, the biblical injunction, honor thy father and thy mother, could not be referring simply to the biological father. In that case, we'd have to honor the man who served us in the course of a rape. It must make the injunction makes sense as it's referring to the moral definition of parenting, the parents who are there to sustain and nurture and protect. And so one of the ways we're seeing this now is that, remember, there's a letter a while back in the Wall Street Journal from a man who was appalled and threatened by the fact that the legislature in California would threaten him with punishment if he dared to seek counsel for a child who's undergoing confusion about his gender. And he was saying, he was hoping that the federal government would come to, yes, well, do our friends take that seriously? Or those parental rights articulated in Meyer and Pierce in the 20s, are they not constitutional rights? And if they are, why could they not be vindicated by the Congress or federal court? We're just getting back to our old question of what do we think is the very ground of these rights?
Well, one ground, well, it's not quite a ground, but it's one support for parental rights is what I believe to be the fundamental purpose of an independent judiciary, going all the way back to Marbury, which was to be a bulwark of limited government, and that the independent judiciary would, as best it could, keep the other branches of government within their proper bounds. So that's one way in which parental rights emerges out of a broader, undifferentiated background. That is to say, it's one purpose of limited government is to protect the autonomy of various non-governmental communities, churches, but especially families. Now, I think the moral grounds of parental rights are not mysterious, although I think they're probably in our world a bit obscured. I think parental rights, for the most part, are the corollary of parental duties. That is to say, parents have obligations, moral obligations of support, education, sustenance to their children. And if you have those obligations, you're entitled to the autonomy or the right, that is the space necessary to perform your duties. But I think that we're a society that has an addled understanding or a misunderstanding of parental duties and thus parental rights. But I think more important, in the tradition, and I think not only in the tradition, but in truth, parental rights were and are inseparable from the marital family. That is to say, we, given the breakdown of the family, can't help but think of parental rights as individual persons, a mother or a father, and their control of their offspring. But I do think that in the tradition and in truth, parental rights were what in the older language would be called an incident of marriage, that it was an aspect or part of what it meant and one of the entailments of being married, mother and father as the foundation and the source of marital family unity, that the children were not the creatures of the parents, but rather the members of a distinct and irreducible, unique family, and that there was a way in which what we call parental rights was actually a way to another way of saying that the children, and this is the old-fashioned legal language, the children are issue of the marriage. The children are their parents' two in one flesh union, kind of extended into time and place. So the relationship of parent and child, traditionally and in truth, had a deeper metaphysical meaning and value. That was finally, I think, the ground of parental rights. But of course, our society, with the willing accomplices in the courts, have decimated that view of the family.
Well, I'll give one word for that. That's gorgeous. Which is say, once again, you take the fragment. You say the fragment makes sense only as it's seen within the larger scheme of what a marriage was, that the children were the issue, the one flesh reflection of the one flesh union. And the whole thing becomes far more comprehensible then. I think that's perfect. That's the way we move.
I
Now,
think that's important. I think that's in a way a general description of the problem we are facing and what we're trying to do at the James Wilson Institute. I mean, it would be something. There must be an image from literature or perhaps cinema that does it, but it's like, picking up pieces of a manuscript strewn around a beach or a cave, and each one of them is only, a few words, and you're somehow caused to wonder what is the real meaning of this sentence fragment. And you speculate and you take feints and false steps, but the only way to actually to know the truth about that is to be able to reassemble the pieces back into a whole. And I think that is true of so many of the so we're taking up the question of transgenderism without trying to deal with the metaphysical truth that we are our bodies. And if you just rule that out of bounds as fancy schmancy platonic speculation, I think it's very difficult, truly difficult to reason soundly about that matter or about abortion without talking about when people begin. Or we have a whole casuistry, I mean, a Byzantine body of law about religion, right? Famously, the Supreme Court has no definition of religion. Go figure.
so this really, in case it has to be pointed out, all of this makes sense only in the presence of that N word, natural law, that we've been doing. It's a natural law perspective, in which case I could end, just take it, then complete it with this one step. Do our friends think that parental rights are there only because the Supreme Court provided them in the 1920s with the Myers case and Pierce? Would they not be there with it's rather like our friends, people who talk about the Bill of Rights and say, those rights I have through the First Amendment. And the old question was, if we didn't have the First Amendment, do you have any doubts that in a free society you would not have a presumptive right to speak, to associate with other people who share their views? Which is, again, are you sure that are we falling into avoid the tendency to assume that those rights are there only because the Supreme Court ladled them out to us in the 1920s, or that the court gave it to us in the Bill of Rights, as though these rights emanated from the positive law, so that, as the lawyers from Tennessee would have it, the legislature has to give us our authority to reject the different forms of medical treatment for children.
Right.
So we
Right.
take it back to the ground of natural law, and we say, okay, that completes the session.
Yeah.
Well,
Okay.
we'll be watching for the outcome of both of these cases, Childs and in Skermeti, before the end of June, when the Supreme Court is likely to rule on both of them. And we'll certainly have commentary on what opinions the court renders in both of these cases. But until then, thank you to our listeners for joining us for this episode of the Natural Law Moment, and we'll see you next time.